Auma and Honorable Nyaga Wambora, which was Civil Supreme Court Petition number 32 of 2014, where the court, in summary, in dealing with Hassan Joe, Said Shabal and other decisions, my lord, Raila Odinga, and in citing the National Assembly Privileges and Immunities Act, Section 12, my lord, Mr. Speaker, insulate this House from any contempt proceedings, number one. But number two, Mr. Speaker, it also insulates this House and other institutions from any claim of interference by other institutions. The Supreme Court, Mr. Speaker, in that matter, defining the independence of institutions as a primacy that must be considered, and the Supreme Court holding our petition in 2014 on the basis, Mr. Speaker, that a house, this House cannot be injuncted by a court. The orders issued by Judge Sergon, Mr. Speaker, cannot therefore stop the proceedings of this House. Mr. Speaker,
just 1 minute.
Mr. Speaker, just to note that a dark cloud hangs over the head of the governor, over the allegations that have been made. What other place would the governor have to clear the allegations made against him other than in this House? I think this is the opportunity for the governor and for the county assembly and the people of Kericho to know whether or not the governor is guilty or innocent of the wrongdoings that have been leveled against him. Mr. Speaker, allow this Senate to make a decision on this matter by going through a substantive hearing of all these allegations. Thank you, Mr. Speaker.
Senator Murango.
Asante sana mstahiki Speaker. Na kwanza ni kushukuru kwa sababu ya kusikiza ombi la kiongozi wa wengi, kiongozi Cheriot, kuwa na wakilishi wandi hapa aweze kusikiza kwa sababu mimi pia nilikuwa mwakilishi wandi. Na ni vizuri pia waone kwa sababu kesho watakuwa watu na maybe watakuwa hapa pia. Mstahiki Speaker, katika kanuni zetu za kundumu ambayo nyongeza ya 3 ambayo inapeana masharti ya utaratibu wa kusikiliza na kuamua mashtaka ya kumuondoa gavana mamlakani. Katika kanuni ya kundumu 80 tukienda katika 12 inasema hiyo masharti yote ambayo imepeanwa ikizingatiwa, gavana atasikizwa na ushahidi utakapoanza utaendelea hadi seneti itakapohitimisha kusikiliza swala hilo. Mstahiki Speaker, tushaanza kusikiliza jambo hili na kanuni zetu za kudumu zinasema ya kwamba inapoanza tunafaa kwenda mpaka mwisho. Kwa hivyo nadhani seneti kwa saa hii haiwezi kuangalia namba ilikuwa namna gani. Tutaangalia makosa ambayo italetwa hapa, tutasikiza pande zote mbili, halafu mwishowe tutakuja sasa kuamua tutakapokuwa tumesikiza kila kitu. Kwa hivyo kwa mahali utatuelekeza mstahiki Speaker, nadhani ni vizuri maseneto wapewe nafasi kuamua jambo hilo, kwa sababu kulingana na venye nimesikiliza kesi kulingana na wakili wa gavana ni kusema kwamba wanakualika kufanya uamuzi. Lakini sidhani kwamba uamuzi unaweza fanywa na speaker peke yake katika muda huu, lakini maseneto wote wanafaa kuja wasikize halafu waweze kuamua. Asante mstahiki Speaker.
Senator Osotsi.
Thank you, Mr. Speaker. Mr. Speaker, indeed, listening to my colleagues, we are confronted with a very important decision to make on how we are going to dispense with a preliminary objection, because the matters raised in the preliminary objections are very weighty from both sides. And I want to agree with the senators who have said that Rule 30 does not apply in this case. It is the senators to make a determination. So, Mr. Speaker, I want to dissuade you from applying Rule 30 and instead let the senators exercise their constitutional right to determine whether the PO stands or not. And looking at the numbers, Mr. Speaker, I want to pick from Senator Muma, who talked about the numbers of women in the county assembly. I think we would need to get some wisdom or a communication from IBC, because from my experience, I know IBC has been doing rounding off. They round off to the next human being. So when we talk about 31.3, I think the next number is 32. That is what IBC has been doing. So I think we need to look at this matter very critically and decide through a vote on how we want to proceed. And if the decision is in support of the governor's preliminary objection, Mr. Speaker, then the whole matter collapses. And that's the position of the law, because it would not make any sense for us to proceed with a matter of this nature if the PO collapses, if the PO succeeds. So, Mr. Speaker, I want to dissuade you from applying rule number 30, but allow the members to make a determination through a vote.
Senator Chute.
Honorable Speaker, I am not a lawyer. I've been in business for many years. And if you look at what is happening in business circles, you'll find that a shopkeeper writes 999, price of 999. Why are they doing this? It's because they want to attract a customer. The price can be 1,000, but he wants to attract a customer, and he puts 999. Referring you to Section 33 of the County Government Act, it clearly says minimum of 2/3. Honorable Speaker, the County Assembly of Kericho should go back and get 32 people, 32 Senate members of County Assembly, and come back to the Senate. Honorable Speaker, you know, we are not here to sacrifice the governor of Kericho. We need to protect each and every person. If that person was brought here in a way that the Constitution has made it very clear that anything that is less than 2/3 is not acceptable. So, Honorable Speaker, 31 is not 32. 31 is 31. If they can bring the governor here with 32 votes, I'll say yes, that's acceptable. So let them do their homework vizuri and come back with 32 votes, and that is how we'll prosecute this case. Thank you very much.
Senator Mutai. Minority Leader.
Asante mstahiki Spika. Mstahiki Spika, jambo la kwanza kwa hivi sasa ni kwamba watu wa Kericho wanaketi wakijua kwamba gavana wao ama kesi yao hivi sasa iko ndani ya Senate. Bwana Spika, hii hoja ambayo iko mbele yetu ya aidha kuweza kusimamisha kusikiza kesi hii ya mstahiki gavana ama kuweza kuimaliza wakati huu iko mbele ya Senate. Bwana Spika, tumekuwa na mifano tofauti tofauti ambayo imekuwa hapa ndani ya bunge la Senate. Nikikumbuka kulikuwa na kesi ya Mheshimiwa Sonko aliyekuwa gavana wa Nairobi. Kitu kama hichi kilitendeka, lakini Senate iliamua ya kwamba itasikiza kesi yote kwa ujumla, alafu mwisho ndio itaamua. Nataka tuchukue mkondo huo ambao uliwekwa wakati ule na bunge hili, nyumba ni hii, ma senators wamegeuka, wengine sio aliokuweko, lakini wale ambao wako hivi sasa wanaweza kufanya kama vile ambavyo tunasema kule nyumbani ya kwamba maji hufuata mkondo. Kwa hiyo hivi sasa tuko na mkondo ambao tuliuweka ndani ya bunge la Senate, ya kwamba kitendo kama hichi kitendeka, alafu wakileta kama hiyo preliminary objection, wacha iwe mojawapo ya zile sababu ambazo tutasikiza hii motion ambayo iko mbele yetu hivi sasa. Kwa hiyo Bwana Spika, nataka kusema tu ya kwamba turuhusu ya kwamba kesi hii ambayo iko mbele yetu iweze kuendelea, tuweke hii preliminary objection kando kidogo, ili tuweze kuichukua pamoja na hizi zingine kama vile tulifanya mfano wa Mheshimiwa Sonko. Asante Bwana Spika.
Senator Mutinda Tabitha.
Thank you, Mr. Speaker, and I want to agree with colleagues on the point that Parliament is independent and so cannot be injected. That one we all do agree. Mr. Speaker, the discussion on table in-house today is the arithmetic discussion. An arithmetic discussion of 31.3. Mr. Speaker, 31.3, as a student of mathematics, less 47 is 15.7. At this point, Mr. Speaker, does it mean that 15.7 MCAs of Kericho did not vote on this motion of impeachment, but then 31.3 did vote? Mr. Speaker, it's very clear we cannot have an arithmetic in terms of a human being. And it's so very clear, Mr. Speaker, that 31 MCAs did vote to impeach the governor, and 16 did not vote, which equivalents that number to 47. A very straightforward situation, Mr. Speaker. If 23 senators vote to impeach a governor, 23 vote not to impeach, and 1 abstains, then the governor is not impeached. What is clear, Mr. Speaker, is that the decision on this PO is a decision by the senators. Even when we shall be voting for the next big assignment on Thursday, Mr. Speaker, 2/3 is equivalent to 44.6. The required number is not 44, but 45. In the event...
Senator Nduati. Senator Nduati. Veronica.
Honorable Speaker, thank you for the opportunity to contribute to the issues at hand, the preliminary points that have been raised, and application. At the very onset, Mr. Speaker, I would encourage you not to take the bait of having to determine what happened.
Is your time up?
No. I've not even spoken
okay,
for 20 seconds.
Proceed then.
Mr. Speaker, I was saying that I would persuade you not to take the bait of having to determine these preliminary points or applications for 2 reasons, Mr. Speaker. They raise such fundamental and weighty points of law, Mr. Speaker, and some have, of course, raised issues of fact, whether service was effected or not effected. Mr. Speaker, if you were to determine these issues, it would bring to a determination of the entire impeachment proceeding. That means you would have abrogated yourself the function of what the Senate is supposed to be doing. Consequently, you should bring these points to a vote by the House, Mr. Speaker, and by the honorable members of Senate. 2, Mr. Speaker, there was an application on the issue of a protection of a witness, a key witness in these proceedings, Mr. Speaker. It's my very considered opinion, Mr. Speaker, that that protection should be afforded to a witness who feels vulnerable, Mr. Speaker, because of the nature of the offenses that have been brought forth, Mr. Speaker. But while giving that protection to this witness, Mr. Speaker, there must be a balance as to how that protection is given. For instance, Mr. Speaker, and if you are guided by the Witness Protection Act, Mr. Speaker, we could take off the proceedings from camera with respect to that witness, but ensure that senators have an opportunity, Mr. Speaker, to hear the kind of allegations so that you balance between the witness not being hidden away from the accused governor, Mr. Speaker, and the senators who are supposed to be judges, but you also ensure that the witness is not exposed to an extent that reputational damage would appear or would occur, Mr. Speaker, in the event that the evidence she's adducing is true, and whether that evidence is true or not will be determined after the witness has been heard. So we should balance the two, Mr. Speaker, but ensure that the witness is protected because of the nature of the offenses, Mr. Speaker. With those remarks, Mr. Speaker, I would urge you to allow the senators to vote on this. I will not.
Senator Munyihaji Faki.
Asante Mheshimiwa Spika kwa kunipa fursa hii. Kimsingi ni kwamba mawakili wa gavana wanataka masuala haya yaamuliwe kabla ya kusikizwa kwa mashtaka ambayo yameletwa hapa na Assembly ya Kericho. Mheshimiwa Spika, tukiangalia bunge la Senate linapokaa kuangalia masuala ya impeachment ni kama mahakama, na katiba yetu inasema katika kifungu cha 159 ni kwamba mahakama zinapokaa haki iamuliwe bila ya kuzingatia masuala magumu ya procedure na vile vile pia kiteknikali. If I may read it in English, Mr. Speaker, is that justice shall be administered without undue.
Senator Faki, choose the language you'd wish to
for
make
the benefit
intervention.
of the samani, Mheshimiwa Speaker.
You started in Kiswahili, proceed in Kiswahili.
Sasa samani, Mheshimiwa Speaker. Kwa hivyo na Mheshimiwa Speaker, swala lililoko mbele ya bunge hili la Seneti ni kwamba Seneti iamue masuala ambayo yamefikishwa mbele yake bila ya kuzingatia mambo ya kiteknikali, kwa sababu tunapozingatia mambo ya kiteknikali tutapoteza ile fursa ya kuweza kutenda haki ya kimsingi. Jambo la pili, Mheshimiwa Spika, ni kwamba bunge la Senate linapiga kura kutokana na masuala ya delegation. Kwa hivyo hili ni swala ambalo linaathiri counties, na kwa masuala yote yanayoathiri counties uamuzi huwa ni wa kupiga kura wa zile delegation 47 ambazo ziko katika bunge hili. Kwa hiyo Mheshimiwa Spika, swala la wewe kukata kwamba swala hili halikutimizwa ama swala la quorum halikutimia katika bunge la Kericho, la bunge la kaunti ya Kericho, Mheshimiwa Spika, hapo utakuwa umekeuka katiba na vile vile pia umekeuka kanuni zetu za bunge hili, ambapo zinasema kwa masuala ya uamuzi iwe ni kwa sababu ni masuala ya delegations ambazo ziko katika bunge hili. Asante sana Mheshimiwa Spika.
Senator Kericho Tabitha.
Thank you, Mr. Speaker, sir, for giving me also the opportunity. And it's true, I agree with my other senators, there is an issue when it comes to the law, that is section 33 of County Government Acts, to really verify and know whether the numbers that the MCAs that approved this motion, whether they met the threshold. But I'm lucky because I happen to have continued my maths, where you reach a point where maths and science go together. So when it comes now to 31.3, the science math says there is no half person, so it should have been 32. The 0.3 is always becomes a whole person, which it should be 32. But now the other big question is, if this motion is returned back to the county assembly, how sure are we that it will not come back within a week? So I think we are now again not very sure whether we are going to save or hurt the people that brought this motion here. But it is true, we've not met the threshold. It should have been 32, not 31. Thank you, Mr. Speaker, sir.
Senator Sifuna. Senator Eddy, certainly you cannot rise on a point of order. There is no senator speaking. Senator Lomenan.
Thank you, Mr. Speaker, for this opportunity. Mr. Speaker, as I've listened to the councils from the both sides, Chair, we have a heavy duty to do in this Senate House, and we need time. Chair, if you see the voluminous books that are with us, there are many contents that we have to listen before we make a ruling. Chair, I will want to urge this House and you, Mr. Speaker, to give us an opportunity as senators or judges to make a ruling of this issue of appeal by making a vote. And then we continue from there, Mr. Speaker. Thank you, sir.
Senator Wamatenga.
Thank you very much, Mr. Speaker, sir, for giving me this opportunity. Indeed, we are invited as senators to do justice to a matter brought before us. But even before we do that, Mr. Speaker, it is our duty and responsibility as the whole country and the whole world watches to ensure that we do justice to matters that are come before us. Mr. Speaker, sir, it has been cited that decisions have been made and precedents have been set. But that notwithstanding, Mr. Speaker, it is also imperative that we interrogate that under which condition those decisions and precedents were set. Mr. Speaker, sir, as an engineer, I know that rounding numbers to the nearest is a common practice. However, Mr. Speaker, sir, we are invited in this matter not to look at the case before us scientifically, but to look at it as is required using the jurisprudence that have been set before. Mr. Speaker, 31.3 cannot meet the threshold. And therefore, I think it is imperative that we as senators move a motion and decide on this matter, determine this matter, even before we go into full hearing, because that is the responsibility that we have, and it is what people expect of us, and it is what we must do as senators. Mr. Speaker, the role of these senators sitting here, when they come and sit as juries, we must make a decision whether the prerequisite preliminaries have been met. If they are not been met, Mr. Speaker, then we must return matter to the sender so that they can meet the threshold and we can be able to be sitting in a matter that is supposed to be sat for by this House. Mr. Speaker, sir, I submit.
Senator Eddy. Senator Eddy.
I thank you, Mr. Speaker. Mr. Speaker, what we're invited to do in this House on two substantive POs, Mr. Speaker. One, I cannot belabor, Mr. Speaker. We cannot be gagged by addition of court from doing our job. So I think that one we are in tandem, Mr. Speaker. On this issue of mathematics, Mr. Speaker, you are invited to make a decision which I think that it is the House that should make. One is a practical question and the other one is a mathematical question. Practically, Mr. Speaker, you cannot have a fraction of human beings reduced to the lower number. And mathematically, Mr. Speaker, I think that it is a question that probably would have needed a judicial review even long before it came to this place, Mr. Speaker. Because constitutionally, this question of 2/3 has never confronted the country. And Mr. Speaker, The only time that we see it, and especially from the cases that has been presented here, is the case for Tana River, Mr. Speaker. So as a House, I think it behooves us to go with the larger question of what has been determined in court. And what has been determined in court as per now, without a judicial review, is the case for Tana River, which then can be the only legal basis and legal framework that then we can be able to use to question this practicality of numbers. But that said, Mr. Speaker, I wanted to urge the House that because this is a very serious issue, Mr. Speaker, and the people of Kericho would want to be heard, perhaps the determination of these two POs should be done with the other substantive issues that have been brought in the House so that senators have got a chance to make observations at the end of this entire process, so that those preliminaries will form part of the conversations and as we go through the charges, and this matter be heard, and then we'll make a determination at the end, Mr. Speaker, because if we don't, then you'll be invited to a very dangerous path, Mr. Speaker, whereby you...
Senator Oroba.
Thank you, Mr. Speaker. I want to add my voice about the victim protection, Mr. Speaker. In the Victim Protection Act, Section 8, it says that any victim has a right for privacy and protection. And therefore, because the proceedings here will be broadcasted, Mr. Speaker, I believe we have no choice but to follow the law and ensure that Section 8, Section 10, and Section 11, particularly on the issue of disclosing the identity of the victim, are taken care of. Mr. Speaker, on the matter of the two-third threshold, Mr. Speaker, this is a house of procedure. We are guided by procedure, and we have our standing order. Our standing order says on the procedure for removal of a governor, within 7 days after receiving notice of a resolution from the Speaker of the County Assembly supporting the removal of a governor, pursuant to Article 181, then the proceedings begin. Mr. Speaker, in that sense, why are we even debating this? There is no opportunity in our standing order where we are told, go back to the County Assembly and check if the threshold was met and check if the allegations were actually substituted. For us, we are quasi-judicial process. They have reached here. As long as we have the notice of resolution from the Speaker, from the County Assembly, our work is to proceed. And for those who feel that the threshold was not met, Mr. Speaker, they can go to court and proceed with that argument there. Thank you, Mr. Speaker.
Senator Asige.
Thank you, Speaker. I have two observations to make. It's my understanding that the Kericho County Assembly consists of 47 members, and Section 33 of CGA requires 2/3 of the votes are needed to support an impeachment motion, which means that the County Assembly needed 31.3 votes. And further, if we use the Nkaduda versus County Assembly of Tana River case, we can infer, because of jurisprudence, that a natural person cannot be fragmented into a fraction. And therefore, the logical thing to do, of course, would be to round off the decimal to the nearest round number. And the nearest round number in this case is 31. Speaker, we are here as a quasi-judicial hearing. And I see us, of course, as judges, very, very strongly so in this case. And Speaker, I also see us akin to scientists who have been given the mandate to deal with this case with precision. This is a laboratory, Mr. Speaker, and we are all scientists, and we have been called to make a very fine cut in this, with these POs. Speaker, science has laws. There is the law of gravity, law of motion, the law of the Mendel's law, the Megan law, several laws, Mr. Speaker, and those are absolute. They cannot be moved. They cannot be wished away. Similarly, Speaker, the High Court has ruled through this jurisprudence that that you should calculate to the nearest round number, and that, Mr. Speaker, is law. it's through a court of law. And I think that we should continue in that way. 31 has been met in terms of votes, and therefore we should listen to this case further and listen to the substantive issues therein. Speaker, also, you have been invited by the Governor's Council to mirror the decision of your counterpart in the National Assembly. I feel that is out of order, Speaker. You are not a conveyor belt. You are not somebody who regurgitates what the Speaker of the National Assembly does or says. You are not a parrot of the National Assembly, Speaker, and therefore being invited to mirror a decision that...
Senator Seki.
Thank you, Honorable Speaker. I also stand to put my voice on this matter. Honorable Speaker, I want to believe that the County Assembly have pronounced themselves, they have presented themselves. The Governor panel has also presented themselves. And now it is the Senate now to determine whether to listen to the PO to proceed with this matter. But I want to assure and believe that this matter will be determined in whichever case, Honorable Speaker. Either we have presented ourselves, we have pronounced ourselves, we have determined ourselves before this case, or even when we determine this case when we are finishing, we listen this case towards the end. I want to believe that this is the right time, that we need to hear both sides, the County Assembly and the Governor, the Governor's team, so that at the end of it all, everything will determine, because we will see if true the County Assembly had the threshold or not, or the Governor has issues that has been accused to. It is going to be determined towards the end. So, Honorable Speaker, I believe that this is a time when we need to hear this case. We need to hear because the process has started, and there is no way we can stop this process. So, Honorable Speaker, I want to support that we proceed with the matter. Thank you very much.
Senator Akinyi Beatrice.
Honorable Speaker, I thank you for giving me the opportunity. Honorable Speaker, the issue that I want to talk to is the issue of the threshold. Honorable Speaker, you can't round off human beings. And if a threshold has to be determined, Honorable Speaker, and it has been stated, to me, Honorable Speaker, there is no way around it. We must look at the issue of threshold, and it must be determined, Honorable Speaker, because we cannot set a precedent that is otherwise. Honorable Speaker, on the PO, if it has to be determined, it is a matter that does not concern counties, and so, Honorable Speaker, I stand guided, but I think all the 67 senators stand to determine, to vote on that. Otherwise, Honorable Speaker, on the issue of threshold, Honorable Speaker, I want to support that the threshold must be met from the word go. Thank you, Honorable Speaker.
Senator Methu.
Thank you very much, Honorable Speaker. I don't want to buttress what my colleagues have said. I want to agree that on the first PO, it falls by the way, because precedences have been said that Parliament cannot be injected on the course of its work. But Honorable Speaker, you've been invited to make a very critical decision, and without speaking on whether the threshold was 31 or 32, both parties have come with arguments and counter-arguments. Why they actually think that 31 would be the threshold, why they think that 32 would be the threshold. Authorities have been cited, especially in the Tana River case, the County Assembly, or Speaker and Kaduda versus the County Assembly, on the number as to at what point you should be able to truncate the numbers, and they actually believe that it should be rounded off to the nearest whole. The defense of the governor through their counsel, Katwa Kigen, they actually feel that even at the very beginning or the inception of this county assembly, there had been set a precedence that 32 would be the number. So, Honorable Speaker, you've been invited to make this particular decision, and this is a weighty decision because if you are to allow this PO, then this impeachment proceeding will fall as at now. We shall not have, the jury will not have had an opportunity to make a decision on this particular matter. It is a very serious invitation, and I would want to dissuade you, Honorable Speaker, from allowing or agreeing to fall prey to Rule 30 of the rules of procedure, that you make this decision on the preliminary objection. Please, Honorable Speaker, allow the 47 delegations to make this decision on whether, well, it could be 67 or 47, whatever would be the case, Honorable Speaker, if it touches on the counties, Honorable Speaker, but allow senators who are the jury, who are the judges on this particular matter, to make this decision. Honorable Speaker, for you on this matter, you are an umpire. You have no dog in this fight. Yours is to just umpire.
Now, honorable senators, we need to make progress. I may take your seat, Professor Minority Leader and Senator Kajwang. I've heard you, and nothing new seemed to be coming out at this juncture. And therefore, for us to make progress, you'll allow me to use Standing Order number 1 to suspend the sitting for 15 minutes so that we resume at 3:30 for me to go consider the interventions you've made and give a way forward on how we are going to dispense with this matter. Because remember, honorable senators, if in the event that we proceed with this hearing, we have to start from the beginning. The hearing hasn't started yet. We are merely dealing with preliminary matters, and therefore time is of the essence. So kindly, honorable senators, we proceed now to suspend the sitting for 15 minutes, and we shall resume at 3:30.
Well, the question of the 2/3, whether that is the threshold was reached or not, still remains unresolved. The Speaker of the Senate, Honorable Amason Jeffa-Kingi, has suspended this sitting for 15 minutes, and the House will be resuming at 15:30, indicating that he needs to consider the deliberations before him with regards to those particular preliminaries objections. And the most important one in this case is the objection that was raised by the governor's legal team with regards to the threshold of the MCAs who supported the removal from office by impeachment of the governor. the governor of Kericho County. The reading of the charges will be done today. And of course, this is
first instance, namely whether in light of the court order, if any, the Senate is able to proceed with the hearing of the proposed removal from office by impeachment of the governor of Kericho County, and secondly, whether as contended by the governor, the threshold of 2/3 required at the county assembly was not met. The third issue on whether the request by the county assembly for arrangement to be made to secure the anonymity of one of the witnesses who will be testifying for the county assembly should not be allowed will depend on the outcome of the first two questions. In respect of the first issue, which is whether in light of the court order, the Senate is able to proceed with the hearing of the proposed removal from office by impeachment of the governor of Kericho County, the Senate has been faced with similar circumstances in the past. On each occasion, the Senate has had to carefully consider two competing constitutional imperatives that arise. On the one hand, Article 2 of the Constitution provides for the supremacy of the Constitution and for the obligation of all persons and all state organs to abide by the Constitution. On the other hand, Article 1 of the Constitution provides that all sovereign power belongs to the people, and this sovereign power is delegated to the various state organs at both national and county level of government. In accordance with the doctrine of separation of powers, each of these organs are required to perform their functions in accordance with the Constitution while observing the principles of comity and respect for jurisdiction as between state organs. In the words of the former Speaker of the National Assembly, the Honorable Kenneth Marende, while delivering a communication in the National Assembly on the 3rd of September 2009, had this to say, and I quote, "Power thus divided presents the absolutism of the executive, the possible anarchy of parliament on the presumption of the judiciary. The operation of the principle of separation of powers both separates the blends powers so that each branch serves as a check and balance on the powers of the other. It ensures the protection of the rule of law and secures the fundamental rights of an individual. The principle of separation of powers has a superficial simplicity, but is in reality inherently complex." In a communication delivered on the 23rd of October 2019, the then Deputy Speaker of the Senate, Senator Professor Kithure Kindiki, had occasion to consider this matter. The matter arose in the context of the proposed removal from office by impeachment of the then governor of Taita Taveta County. The senator for Taita Taveta County, then Senator Maruma, rose on a point of order and sought the directions of the Deputy Speaker on whether it was in order for the Senate to continue deliberating on a motion and taking further action while there was active proceedings in the matter. In the course of communication, the Deputy Speaker explained why an injunction of Parliament was untenable. The Deputy Speaker stated as follows, and I quote, "Firstly, an injunction by the court against Parliament is a frontal and deadly attack on the substrum and hallowed legal doctrine of separation of powers, the bedrock of our Constitution. Separation of powers creates separate and distinct arms of government with equal but different powers. Each arm must exercise its powers in a fine balancing act to ensure that it carries out its functions without infringing on the powers of another branch of government. Secondly, curtailing Parliament's constitutional responsibilities undermines the sui generis nature of Parliament. Members of Parliament are direct representatives of the people, and thus Parliament cannot be prevented from giving a voice to the will of the people of Kenya. There are checks and balances within the separation of powers, such that while Parliament should fulfill its responsibilities unabated, the courts will have their say in the exercise of judicial authority to declare any legislation or other output of Parliament illegal, unlawful, or unconstitutional. And thirdly, attempts to injunct Parliament are inimical to the desired levels of institutional comity and cordial relations among the branches of government. Intergovernmental relations survive on interinstitutional respect and difference in a mutual manner on the basis of reciprocity. Parliament ought to respect the judiciary, and the opposite is also true. Now, honorable senators, ladies and gentlemen, the Supreme Court and the petition number 32 of 2014, that is Justice Kericho Mutai and another versus Martin Nyaga Wambora and another, 2017, also had an occasion to consider the competing constitutional imperatives and Articles 1 and 2 of the Constitution in what will be described in legal parlance as the locus classicus on this particular matter. In this matter, therefore, the Senate had resolved to remove the then governor of Embu County, Governor Martin Wambora, from office by impeachment. Additionally, the High Court had issued conservatory orders, the effect of which were to prevent the impeachment of the governor. Following his impeachment, the governor challenged the impeachment by an application before the High Court and sought interim orders for his reinstatement into office and an order of contempt of court against the appellants, that is the Speaker and Clerk of the County Assembly of Embu, for allowing an impeachment motion to be discussed, passed while a conservatory order was in place. The governor was successful in his application. The court held that all proceedings conducted in disobedience of the court orders were null and void and found the appellants guilty of contempt. Aggrieved by this decision, the appellants filed an appeal at the Court of Appeal challenging the findings of the High Court. The Court of Appeal affirmed the findings of the High Court, leading to the appeal to the Supreme Court. Before the Supreme Court, the appellants asked that the trial court ought to have noted the legitimate dilemma facing the Speaker of the County Assembly, who was subject to constitutional timelines, yet was faced with a court order stopping the process. It was urged and argued that in this case, that the Speaker had complied with the Constitution in the context in which the question of constitutional obligation on the one hand and the burden of knowledge of the court order on the other were at stake, and asked the court to clarify to what extent parties would be in violation of legal requirements if court orders that conflicted with constitutional deadlines were binding on them. In rendering its decision, the Supreme Court made reference to the decision of the Court of Appeal in the case of Mumo Matemo versus Trusted Society of Human Rights Alliance and two others, Civil Appeal number 290 of 2012, where the Court of Appeal adopted the High Court's position on the doctrine of separation of powers to this effect. I quote, separation of powers must mean that the courts must show a deference to the independence of the legislature as an important institution in the maintenance of our constitutional democracy, as well as accord the executive sufficient latitude to implement legislative intent. Yet, as the respondent also concede, the courts have an interruptive role, including the last word in determining the constitutionality of all government actions. The Supreme Court further made reference to its decision in the Speaker of the Senate and another versus Attorney General and four others, reference number 2 of 2013, and noted that the court had cautioned against interference with running processes in other arms of government and had this to say, and I quote, "This court will not question each and every procedural infraction that may occur in either of the houses of parliament. The court cannot supervise the workings of parliament. The institutional committee between the three arms of government must not be endangered by the unwarranted intrusion into the workings of one arm by the other." The Supreme Court aptly summarized the principles applicable to separation of powers in Kenya context as follows: that each arm of government has an obligation to recognize the independence of other arms of government. 2, each arm of government is under duty to refrain from directing another arm on how to exercise its mandate. 3, the courts of law are the proper judge of compliance with constitutional edict for all public agencies, but in exercising their judgment, courts should be objective. And 4, for the due functioning of constitutional governance, the courts are to be guided by restraint, limiting themselves to intervention in requisite instances upon appreciating the prevailing circumstances and the objective needs and public interests attending to each case. And lastly, in the performance of the respective functions, every arm of government is subject to the law. In the end, the Supreme Court upheld County Speaker Justice Kericho's appeal and nullified the conservatory orders that had been issued in this matter. In a more recent Court of Appeal case, that is civil application number E093 of 2023, the Honorable Kawira Mwangaza versus County Assembly of Meru and others, the Court of Appeal also considered the issue of whether a court has jurisdiction to intervene in an impeachment process that is provided for in the Constitution and which has strict timelines for determination. In its ruling, delivered on the 27th of October 2023, the Court of Appeal, while relying on the decision of the Supreme Court in the Embu impeachment matter, held as follows: that the courts cannot, in the first instance, intervene in the impeachment of the applicant. This is because of the strict timelines provided by the law. The Supreme Court decision of Justice Kericho matter is binding on this court. The preliminary objection is therefore upheld. This court lacks jurisdiction in the first instance to consider the merits of the applicant's application, which sought conservatory orders before the impeachment process has run its constitutional and legal course. Now, honorable senators, ladies and gentlemen, I note that the constitutional mandate to impeach a governor is assigned to the County Assembly and the Senate. Article 181 of the Constitution provides the circumstances under which a governor may be removed from office. In line with the terms of Article 181(2) of the Constitution, Parliament duly enacted the County Governments Act, Cap 265, which at Section 33 sets out the procedure to be followed in the proceedings for the proposed removal of a governor. Further, Standing Order 8 of the Senate Standing Orders also provides for the procedure for removal of a governor from office. These provisions provide for strict timelines to be followed by the Senate in such proceedings. Honorable Senators, constitutional and statutory timelines cannot be wished away by the issuance of ex parte orders, as this will jeopardize the Senate's constitutional and statutory obligations. Professor Kithure Kindiki, the then Deputy Speaker in the Senate, could not have put it in a better way in a ruling that he delivered on the 23rd of October 2019, when he ruled, and I quote, "I respectively but firmly determine that beyond peradventure, courts of law cannot and shall not stop or attempt to prevent Parliament from undertaking its constitutional mandate. Neither can the judiciary compel any action to be undertaken by Parliament. I rule any injunction interfering with the work of Parliament has no effect on Parliament in exercise of its constitutional functions. Such court orders have no effect on the National Assembly or the Senate or any of their committees, respectively. In the unlikely event of any such orders, Parliament and its committees shall proceed unabated, unfettered, and unhindered, as may be directed by the respective Speaker of Parliament." Now, the question of the effect, if any, of the court orders injuncting the Senate from conducting any business is well settled. In this respect, the determination on the question is the same regardless of the position advanced by the County Assembly. Whether or not there was, in fact, a court order in this matter does not matter. Nothing turns on it. The result is the same, which is that Parliament cannot be prevented from the discharge of its constitutional functions by dint of an order of the court. The second issue then is for the second issue for determination then is whether, as contended by the governor, the threshold of 2/3 required at the County Assembly was not met. Related to this question is whether this is a question of fact, necessitating evidence to be adduced by the county, as contended by the County Assembly, or a pure question of law requiring to be determined before the proceedings can continue. In other words, is this a classical preliminary objection or not? This question is important because in virtually all impeachment proceedings before the Senate, preliminary objections have been raised, and in no instance has the Senate terminated proceedings on the basis of a preliminary objection. Successive speakers have ruled that a preliminary objection would be considered together with the evidence and determined on the merits of the matter. In truth, the findings have meant that the preliminary objection raised did not fit within the true character of a preliminary objection. Now, a preliminary objection was defined in the case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors 1969, EA 696, as follows. A preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of pleadings, and which is argued as a preliminary point, and which, if argued as a preliminary point, may dispose of the suit. A preliminary objection raises a pure point of law which is argued on assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has not been ascertained or if what is sought is the exercise of a judicial discretion. In this case, it is not in contention that the County Assembly of Kericho has 47 members, and that one of these members voted in favor of the motion for the proposed removal from office by impeachment of the governor of Kericho County. The only question that has arisen as a preliminary matter is whether the 2/3 threshold was met and the consequence if such threshold was not met. Linked to this question, it is the question whether this is a matter to be determined by the Speaker under Rule 30 of Part 1 of the third schedule to the Senate Standing Orders, or a matter to be determined by plenary. This matter was argued by counsel for the governor in support over determination by the Speaker, while the County Assembly took the opposite view. Senators who spoke supported the view advanced by the County Assembly. It is not in doubt that the trial court in impeachment matters is the Senate. It is, however, also not in doubt that Rule 30 vests in the Speaker as the presiding officer the power to make certain determination for purpose of continuity of proceedings, of impeachment proceedings. Nevertheless, taking one thing with another, and in the context of the totality of the current proceedings, I rule that the question on whether to uphold the preliminary objection raised by the counsel for the governor on the matter of whether the threshold for impeachment was met will be determined in the present case by a vote of the Senate. This is so because, as earlier explained in this ruling, the preliminary objection raised in the present case is of such momentous character that it goes to the substratum of the impeachment proceedings and has the prospect of terminating the proceedings at this point. The County Governments Act and the Senate Standing Orders did not contemplate a situation where the Speaker is called upon to terminate the proceedings in a proposed impeachment without the participation in that decision by the Senate. I further rule that considering that the effect of this vote could be a determination of the impeachment process as a whole, this is a matter concerning counties. And accordingly, the preliminary objection will be upheld if supported by 24 delegations. In such event, the present proceedings will forthwith terminate. The procedure for going to this vote, honorable senators, will be motion in the usual manner, preceded by a notice of motion. The vote will be taken upon the conclusion of debate in the usual manner, and to this end, I have directed the clerk to prepare and circulate a supplementary order paper containing the notice of motion and the motion as soon as I conclude with this ruling. One further matter from the preliminary issues raised remains outstanding, which is the matter of the request made by the County Assembly for the protection of the witness. This question will only become relevant after the disposal of the motion. It is so directed. Thank you. Clerk, kindly circulate the supplementary order paper so that we get down to business.
Senate Majority Leader ni nani? Well, the senators are currently waiting for the supplementary order paper to be availed to them. Remember, this is as directed by the Speaker. The rulings on 2 preliminary objections that had been raised by the governor's legal team. One of them, the Speaker has ruled on, that is with regards to the court order on the matter of impeachment or removal from office by way of impeachment of the Kericho governor. And right now, the other preliminary objection that the senators were considering was with regards to the threshold. The votes that supported the impeachment of the Kericho governor were 31 MCAs. This being a number that was contended by the legal team, indicating that the threshold, which is supposed to be 31.3, following the number of the MCAs, that it's 47, and that by 31 the threshold has not been met. So that is an objection. The Speaker has left it in the hands of the delegation, the 47 members of the Senate, who in a few will be taking a vote on whether the threshold was met or not. But the procedure, as indicated or directed by the Speaker, is that it will...
Let us take a seat. Clerk, proceed to call the next order, please.
Order number 2, notice of motion.
The Majority Leader.
Mr. Speaker, sir, I beg to give notice of the following motion. That aware that pursuant to Article 181 of the Constitution and Section 33 of the County Governments Act, on Wednesday, 2nd October 2024, the County Assembly of Kericho approved a motion for the removal from the office by impeachment of the Honorable Dr. Erick Mutai, Governor of Kericho County. Noting that by the letter reference number KCASP/3 volume 1434, dated Wednesday, 2nd October 2024, and received in the office of the Speaker on the same day, the Speaker of the County Assembly of Kericho informed the Speaker of the Senate of the approval of the motion by the County Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly, including the list of 31 out of 47 members of the County Assembly that voted in favor of the motion for removal from office by impeachment of Honorable Dr. Erick Mutai, the Governor of Kericho County. Also noting that one of the primary objections raised by Honorable Dr. Erick Mutai, the Governor of Kericho County, was that the requisite threshold for passage of a motion for the removal of a governor from office by impeachment being 2/3 of the members of the County Assembly, as provided for in Section 33 of the County Government Act and Standing Order 74 of the Standing Orders of the County Assembly of Kericho, is 32 members of the County Assembly and was not met. Now, therefore, the Senate resolves to uphold the preliminary objection on the threshold required for removal of the governor from office by impeachment, provided for in Section 3 of the County Government Act and Standing Order 74 of the Standing Orders of the County Assembly of Kericho, and forthwith terminates the hearing on the proposed removal from office by impeachment of Honorable Dr. Erick Mutai, the Governor of Kericho County. Thank you, Mr. Speaker, sir.
Next order.
Order number 3, motion. Preliminary objection by the Governor of Kericho County on the threshold applied for the proposed removal from office by impeachment of the Governor of Kericho County by the County Assembly of Kericho.
Majority Leader.
Mr. Speaker, sir, I beg to move the following motion. That aware that pursuant to Article 181 of the Constitution and Section 3 of the County Government Act, on Wednesday, 2nd October 2024, the County Assembly of Kericho approved a motion for the removal from the office by impeachment of the Honorable Dr. Erick Mutai, Governor of Kericho County. Noting that by a letter reference number KCA SP3 Volume 34, dated Wednesday, 2nd October 2024, and received in the office of the Speaker on the same day, the Speaker of the County Assembly of Kericho informed the Speaker of the Senate of the approval of the motion by the County Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly, including the list of 31 out of 7 members of the County Assembly that voted in favor of the motion for removal from the office by impeachment of Honorable Dr. Erick Mutai, the Governor of Kericho County. I beg to move. Mr. Speaker, sir, also noting that one of the primary objections raised by Honorable Dr. Erick Mutai, the Governor of Kericho County, was that the requisite threshold for passage of a motion for the removal of a governor from office by impeachment, being to that of the members of the County Assembly, has provided for in Section 3 of the County Government Act and Standing Order 74 of the Standing Orders of the County Assembly of Kericho is 32 members of the County Assembly and was not met. Now, therefore, the Senate resolves to uphold the primary objection on the threshold required for removal of a governor from office by impeachment provided for as a Section 3 of the County Government Act and Standing Order 74 of the Standing Orders of the County Assembly of Kericho, and forthwith terminate the hearing on the proposed removal from office by impeachment of Honorable Dr. Erick Mutai, the Governor of Kericho County. Mr. Speaker, sir, I beg to move and request Senator Mazayo to second. Thank you, Mr. Speaker, sir.
Senator for Kilifi, you have difficulties. Okay. Proceed.
Mr. Speaker, reading the mood. Let me second.
No, Honorable. Order. Senator Chimera. Now, Honorable Senators, I'll proceed to propose the question. That aware that pursuant to Article 181 of the Constitution and Section 33 of the County Governments Act, on Wednesday, the 2nd of October 2024, the County Assembly of Kericho approved a motion for the removal from office by impeachment of the Honorable Dr. Erick Mutai, Governor of Kericho County. Noting that by a letter reference number KCA/SP/3 Volume 1, /4 into bracket 34, dated Wednesday of 2nd October 2024, and received in the office of the Speaker on the same day, the Speaker of the County Assembly of Kericho informed the Speaker of the Senate of the approval of the motion by the County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly, including the list of 31 out of 47 members of the County Assembly that voted in favor of the motion for removal from office by impeachment of Honorable Dr. Erick Mutai, the Governor of Kericho County. Also noting that one of the preliminary objections raised by Honorable Dr. Erick Mutai, the Governor of Kericho County, was that the requisite threshold for passage of a motion for the removal of a governor from office by impeachment being 2/3 of the members of the County Assembly, as provided for in Section 33 of the County Governments Act and Standing Order 74 of the Standing Orders of the County Assembly of Kericho, is 32 members of the County Assembly and was not met. Now, therefore, the Senate resolves to uphold the preliminary objection on the threshold required for removal of a governor from office by impeachment, provided for in Section 33 of the County Governments Act and Standing Order 74 of the Standing Orders of the County Assembly of Kericho, and forthwith terminates the hearing on the proposed removal from office by impeachment of Honorable Dr. Erick Mutai, the Governor of Kericho County. Now, Honorable Senators, of course the floor is now open for you to debate this motion. However, if you may have noticed, debate actually preceded this motion. And with your consensus, therefore, and even assuming this motion is defeated, assuming, it means we have to start the hearing. It is now going to 5. And the case of the County Assembly has to be heard today, in the event that this motion is defeated. With that, Honorable Senators, would you then allow me to proceed and put the question? Yes. Very well. So I will now proceed to put the question. That aware that pursuant to Article 181 of the Constitution and Section 33 of the County Governments Act, on Wednesday, 2nd of October 2024, the County Assembly of Kericho approved a motion for the removal from office by impeachment of Honorable Dr. Erick Mutai, Governor of Kericho County. Noting that by a letter reference number KCA/SP/3 Volume 1, /4 into brackets 34, dated Wednesday, 2nd of October 2024, and received in the office of the Speaker on the same day, the Speaker of the County Assembly of Kericho informed the Speaker of the Senate of the approval of the motion by the County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly, including the list of 31 out of 47 members of the County Assembly that voted in favor of the motion for removal from office by impeachment of Honorable Dr. Erick Mutai, the Governor of Kericho County. Also noting that one of the preliminary objections raised by Honorable Dr. Erick Mutai, the Governor of Kericho County, was that the requisite threshold for passage of a motion for the removal of a governor from office by impeachment being 2/3 of the members of the County Assembly, as provided for in Section 33 of County Governments Act and in Standing Order 74, the Standing Orders of the County Assembly of Kericho, is 32 members of the County Assembly, and that number was not met. Now, therefore, the Senate resolved to uphold the preliminary objection on the threshold required for removal of a governor from office by impeachment, provided for in Section 33 of the County Governments Act and Standing Order 74 of the Standing Orders of the County Assembly of Kericho, and forthwith terminates the hearing on the proposed removal from office by impeachment of Honorable Dr. Erick Mutai, the Governor of Kericho County. Now, Honorable Senators have already ruled that this is a matter that concerns counties, and therefore voting shall be by delegations. We are going to vote electronically. And therefore, at this juncture, I will ask Honorable Senators to remove their cards from the delegate unit. Yeah. You may proceed to. We will get there, Senator Fernandez. And Sergeant, at times you can move around and pick unattended cards. And at this juncture, I will ask the Sergeant at arms, as they do that, to ring the division bell for 5 minutes. Sergeant at arms, as you collect the unattended cards, ring the division bell for 5 minutes.
Well, senators are about to take a vote on whether they agree to the motion. This is a motion that is that regards the preliminary objection by the governor of Kericho County on the threshold applied for the proposed removal from office by impeachment of the governor of Kericho County by the County Assembly of Kericho. This is a motion that seeks the senators to either uphold that preliminary objection. Remember, the governor's side had indicated that the threshold by the MCS to remove him from office from the County Assembly had not been reached, and that is the motion that the senators will be taking an electronic vote on. If they uphold that particular preliminary objection, of course, now that will be siding with what the governor is saying, then that would be the end of this particular impeachment process, since it will have terminated the hearing on the proposed removal from office by impeachment of that governor. If they do not uphold or object to that particular preliminary objection, then the proceedings will continue or will start as had been indicated by the Speaker. This is an electronic vote. That bell is for the senators to be able to check on their cards. Once that bell is off, then the door will be closed and the bars drawn. Those who will be participating are the 47 senators. This is county delegation voting, and by county delegation means that each county delegation shall have one vote to be cast on behalf of the county by the head of the county delegation, in this case a senator who, in pursuant to the provisions of Standing Order 83 of the House, terms a county delegation or terms one senator as a county delegate or delegation, and in this case then it is only 47 senators who will be voting once that bell stops for the members to be able to take that electronic vote. This is a procedure that will determine, or shortly will be able to know, that whether the proceedings of this impeachment hearing will continue or will not continue. Once the voting starts, or during the electronic voting, senators shall cast their votes by pressing the yes, the no, or the abstain button. Once the electronic voting starts, the senators shall cast their votes by pressing the yes, the no, or the abstain button at the expiry of the 5 minutes. As soon as the result of the voting appears, then the indicator board or the speaker, as the case may be, if he shall announce the results of the division forthwith. So, as the bell is on, the senators are preparing to take that vote. Once the vote starts, or that the voting starts, and we understand that we'll be expecting to see the numbers of the members who will be voting, we shall be projecting that particular board on where the voting is taking place. We shall be able to see the numbers of those who are voting yes, also be able to see those who are voting no, and as well also be able to see those who may be abstaining from taking this particular vote. Out of 47 members, the vote may be within 24 senators or 25 to indicate that the vote has taken a certain side. Either they have upheld the preliminary objection on the threshold as indicated by the governor's side, or they are not upholding that particular preliminary objection. That is a bell that the members currently are checking on their cards. It will be electronic voting. And once that is done, the doors will be closed and bars drawn for the voting to take place.
Kindly close the door and draw the bar. Honorable senators, take your seats. Senator Muma and Senator Lekina, please take your seat. Honorable senators, as I had already indicated, voting shall be done electronically, and therefore you may now proceed to log in. Honorable senators, you may now proceed to log in. Proceed to log in and vote. Time is running. Honorable senators, cast your vote. Order, honorable senators. Senator for Homa Bay. Take your seat, please. Thank you. Now, honorable senators, the result for the division is as follows. Ayes at 34, nays at 10, abstention at 0. So the ayes have it. Sergeant at Arms, you may now withdraw the bar and open the door. Now, honorable senators, the motion having been approved, the hearing proceedings on the proposed removal from office by impeachment of Honorable Dr. Erick Mutai, the Governor of Kericho County, hereby terminates. And the Senate now stands adjourned until tomorrow, Tuesday at 9 a.m.
Two of the most decorated clubs in English football. It is always a big deal with these two. And Garnacho! That is off the very high.
Stream all Premier League games wherever you are on Showmax Premier League. Available now on Showmax.
Good morning. Welcome back. You're still watching Daybreak on this 7th day of October 2024, just the day before the National Assembly considers the motion against Deputy President Rigathi Gachagua to impeach him on about 11 grounds. We're here to talk about that, the process itself, the grounds themselves, and what would be the threshold. And of course, in studio, I have Fred Okango, who is Political Affairs Secretary from KANU. Good morning, Fred.
Good morning, Sam.
Ndegwa Njiru, Wakili.
Yeah.
Good morning.
Good morning, Sam.
Well, this is Diana Gishengo, also a Wakili, but also the National Coordinator of the Institute of Social Accountability. Good morning.
Good morning.
And Juan Ogola is an advocate of the High Court. Good morning.
Steve Ogola, not Juan Ogola.
Good morning, sir. Thank you.
Good to see you. And of course, so the papers, Ruto locks out his friends. That's what the Standard is saying. Rattled by recent political events in the country, President William Ruto, previously an open and affable leader, is tightening control, enforcing strict access protocols and reshuffling long-serving staff allies. Allies need permission to see him. And you say that all this is happening as Gachagua pleads for forgiveness, and you have heard some of those voices in the news. We'll be having some of them later on. Gachagua's last options, the DP and his allies fancy his chances are better at the sober and more objective Senate. This is on the Daily Nation, and he's saying, please forgive me. DP Gachagua yesterday made an impassioned plea for forgiveness, even as his team sought ways of fighting the impeachment motion against him. With MPs expected to vote on the matter tomorrow, will President Ruto play his hand and save his embattled deputy president? And allow me to begin with you, Wakili Ndegwa Njiru.
Yeah.
Even before we get to the grounds and, of course, the sentiments of the deputy president yesterday, I mean, what happened that you're now, at this point, look at the papers, what they're saying,
yes,
seeking forgiveness?
You're asking me to comment on what happened, that the DP is now seeking forgiveness.
Yeah.
You know, we must first of all agree that impeachment is a political process.
Mm-hmm.
There is very, very legal aspects involved in it, most especially when you go to the National Assembly and the Senate.
Mm-hmm.
And this I'm speaking from experience of the several impeachments that I have held, that facts and law plays a very minimal role when it goes to the members of parliament.
Mm-hmm.
And of course, this has been follow up to what the various impeachments that have happened in America. Sometimes the Supreme Court of America also indicated that impeachment is a political process.
Mm-hmm.
So politicians will play their role out there. They will maneuver in a manner that will assist them deal with the particular challenge.
Mm-hmm.
And I believe that's where the DP was coming from. Because he's a politician, he's dealing with his fellow politicians. It will only mutate into a legal issue when the matter gets to the judiciary or to courts.
Right.
That's when now we're able to square out what the